Okay, it is 7:03 p.m. and today is Monday, November the 15th, 2021. Welcome to week number 2 of Drugs and Crime, and I'm Richard Wright. And again, I'll be your professor until the exact date when the course ends is December the 17th, but I'll be reminding you of that every week. And there's a reason why I do that. So let's go ahead and get started. Let me share my screen. Okay. Let's see, it should be sharing. Okay, let's hit this one. Okay. They keep making changes in this system. And every time they make a change, they don't notify us and we find out the hard way. Well, this is what you see when you first open up your course. And so I usually start out with um, the, the grade book. As you can see with the grade book, it shows the assignments from week 1 that are 21 students completed them. 19, that's a discussion post. 21, 19 did the assignment, impact of controlled substances. And then um, those of you who submitted the quiz, I actually have, I don't grade those, the computer grades it, and then the live classroom phrase as well. Now, I do want you to know that your grades will be posted and completed by the end of this week. They're due by Friday at 11:59 p.m. Central Standard Time, and every Friday, 11:59 p.m. Central Standard Time, they will be due. So look for week 1's assignments, okay? In a few minutes, we're going to go over a discussion of mandatory sentencing for drug-related crimes for this week, as well as the history of drug and alcohol-related legislation. We'll deal with that, okay? But first, let's start out with the calendar. I always like to start out with the calendar, and I like the month view, and it showed you that the course, of course, began on the 10th, which was last Wednesday, and then we had our open house lecture, and then your initial posts were due and reply posts both were due Saturday, okay? If you submit them Sunday, you're not going to get points for them. Your assignments were due then on the 14th. So now, this is where we are right now, okay? We are at the 15th, but your initial post, notice now, will be due on Tuesdays, along with your live lectures, which take place on Tuesdays at the same time, 7 o'clock p.m. Central Standard Time, and last for roughly 1 hour. Your reply posts, again, are due Saturday the 20th. Your written assignment is due on Sunday, and live lecture and quiz. Okay, let's see what was the comment in the chat box. Okay. You didn't see a quiz for last week? Is that what you're saying? or are you talking about this week? Which one? Which one are you talking about? Week 1 or week 2 or both? Okay, since you're not saying anything, what I will do is I will show you. Okay, let's go back to the drugs and crime course. Let's go back to the assignments for last week. There was a quiz. Week 1, there it is right there. I can't click on it. And I know you could see it in your module, but it's there. If you when you click on assignments, this is the assignment, it would open up the quiz. And then I mentioned it during the live lecture. If you're talking about, let's go back to week 2, which is now. It is also available. So it says quiz. But yeah, it's in there. And then, like I said again, I covered it during the lecture. All right. I can't tell you if, well, it doesn't show. I can't show you while I'm recording this that whether you did the lecture, I mean, whether you did the quiz or not. But there's a quiz that takes place almost every week, except when you get to week number 6. Week number 6, it is not a quiz, it's a final exam. But all weeks before that, there is a quiz. So you have to be careful and watch that. All right, plus, if you look at the announcements, which I'm going to go to right now, you'll see from week 1 announcement, it mentions the quiz and in the as an assignment, along with the written assignment, controlled substances, that was due on this past Sunday. So let's look at week 2 announcement. Week 2 announcement says, Module 2, History of Legislation Regulating Drug Use and Abuse is what we're going to focus on. And you have chapters 5 and 8 of the textbook, which I've sent you the PowerPoints previously for your study. And then we're going to go over regulation of drug precursors, regulation of synthetic drugs, and we're going to look at a video for economic of crack dealing and federal drug activity laws. And so, again, that shows the lecture begins tonight, Tuesday, at 7 p.m. Discussion assignment, mandatory sentencing for drug-related crimes, and you also have the history of drug and alcohol related policies. That's written assignment, and also the quiz, and that's due Sunday. And adversity is a springboard to success is my motto, which I shared with you, that if you were to click on this, you would be able to see what that is all about. And it's all about how I overcame challenges to become successful in life. Okay. So let's see if there's anything else in here. Okay. So now you know about how the quiz works. I don't know how you missed that though. All right. So now let's take a look at the actual module. Um, so let's look at the assignments first. I have the wrong class. Wait a minute. Oh, duh. My bad. You're right. Because last time I taught. Okay, you're right. My, this is constitutional law. Okay. Oh, there is no quiz. You're right. Okay, I did hit the wrong button. That's why. And that is tomorrow night. This is Monday the 15th. Thank you, Valerie, because I was trying to figure out how you could have missed that though. But okay, well now you know what's coming in the future. There's some students who are in both classes, so let's go back and let's take a look at the calendar because it's basically the same thing. Okay, so the month, that is just funny. Um, the course started last week, and our meeting open house was the 11th, Veterans Day, which was Thursday. And your initial post and reply posts were also due Saturday, and your written assignment and live classroom lecture were due on Saturday. Okay, so now our live lectures are Monday nights. Monday nights. An initial post due tomorrow night, and then your reply post due Saturday, and then live classroom lecture and written assignment. No test in this class. Okay. That just goes to show you that we professors are humans too. But I can laugh at myself because um, that was a mistake that when people look at us, they're gonna say wrong lecture. I said no, this is the right lecture. So all right, so it is welcome to Constitutional Law Week 2. Okay, all right. Thank you. You know what? If you weren't here today, if I was by myself, I probably would have gone through the whole lecture and then would have had to record it all over again. So thank you for catching that for me. I know you were trying to scratch your head on that one there. So let's go back to the announcements. Okay. That's funny. Module 2, the 14th Amendment and Exclusionary Rule. We're going to have a little fun with this one. I love teaching this course because the subjects are very apropos to most of what you guys will be doing in criminal justice, regardless of what area you work in. So chapter 7 of the textbook, and then I sent you the PowerPoints for that as well. And we deal with the 14th Amendment, the exclusionary rule, 14th Amendment research starter, and exclusionary rule research starter. And then we're going to go over these issues, as I said, about the 14th Amendment, the exclusionary rule, and then we're going to do a knowledge check to help you out at the end. So that's the announcement. And again, there's my motto there. Okay. So now let's take a look at the written assignments. Okay. So we start out with the U.S. Supreme Court and the exclusionary rule. Now, let me say this to you right now. Please, please, please hear this, because it's going to make a difference in the points that you get. And I'll say this every week. When you see a case such as Hudson versus Michigan and Missouri versus McNeely, when you see cases, when you provide in your paper citations, that, remember this is an APA paper, all right? Citations in the body, references at the end, Roman 12, it should be, and this in this case, let's see, there is a page limitation of 3 pages minimum, 3 minimum. So very important points. When you cite Hudson versus Michigan or any other cases, use the official United States Supreme Court citation. So I think that if you, and then put it in here, but I think if you click it, it's going to go show you Oyez. But don't use Oyez as your citation. Please do not. Use this one, 547 US 586. That's the actual citation. Please do not use Oyez, because I'm going to take points off for not citing the official court citations. I am really a professor who believes in students using their sources for research, but then when they have cases, especially when they're U.S. Supreme Court cases, to use the official citation. And that's it. You won't find the page, but it's just telling you that this is where you find it, but this is where you find the information about the case. And the justices, a 5-4 decision, a knock and announce rule. Okay, so you'll deal with that. Same thing with Missouri versus McNeely. There it is again. So please be sure that you got that point. You got that point about official U.S. Court citations, court case citations. You got it? Okay. Now, the other thing is that, of course, what you should know, and knowing APA, it's okay. You can cite it fully all the way through the paper, but you don't have to. You know how to cite. Once you cite it the first time, and early in the paper, you use it. When you cite it again, you know how to cite it without having to use the full citation. That's the thing that you wanna be able to do. All right. Now you can do the full court citation all the way through. I have some students who prefer that. You're not going to lose points for that. But I guarantee you will lose points if you don't have the full court citation and the official one. And why am I doing that? The reason I'm doing that is because I'm training my students to use official court sources or legal sources, since you're going to be in, not necessarily become a lawyer, which some of you may be, as you know, that's what I am, a retired lawyer, police officer, investigator, paralegal, law clerk, all the 9 yards. And I was a defense attorney most of the time. But you want to make sure that you get into that habit, because documents that you will be preparing as a professional will call for that. So you got a 3-page, 2.5 pages will not cut it. You will see when I get to the rubric. Summarize the facts of each case. Do not copy and paste the ones that you see. In your own words, explain how the exclusionary rule was applied in each of these 2 cases. Identify how any of the exceptions to exclusionary rule have applied. So explain how the exclusionary rule was used. What was the result? And then credible sources, which is APA formatted, and we know what that is. And please have a reference page, separate one, and a cover page. Professional language and spelling. And then here's the tutoring if you need it. I do run all your papers through Grammarly. Okay. It says you got one attempt allowed. Actually, I allow more than one attempt. I allow unlimited attempts. Okay, so let's save that. Save that. Save it. Oh, here it is. So now it's unlimited attempts. And the reason why I do that is because sometimes students will start a paper and number one, they'll submit either the wrong paper, as I had a couple of students to do, or they'll realize, oh, their paper didn't satisfy all the requirements and it's still before the due date. And I will then grade both of them. So you don't even have to tell me to ignore the second attempt. But I want you to be able to do that, because if I just leave that one in there, then you can't correct that, and I don't want that to happen. So I try to go through at the beginning of the course and change them all to unlimited. All right. So okay, let's look at the rubric before I leave this topic. Okay, so as you will learn, or many of you who know me already and from other classes, I operate in mastery. The reason why I operate in mastery is because, as I said in my lecture last week, I work with honor roll and dean's list students. So you'd say to me, well, I'm not an honor roll or dean list student. Well, then it's time to start. I help you get started because I want A's and B's. I hate putting in the grade book C's and D's and F's for my students. It breaks my heart. But I try from day one to make sure that you actually have that information. So student asked me once, why do I keep looking like I'm looking up in the ceiling? It's because my laptop is on my desk in front of me, which I'm looking at right now. But then when I look at the big monitor in front of me, which I can see it much bigger, um, then it looks like I'm looking up, but it's actually in front of me, but it's just above the camera. So anyway, mastery. I want you to pretend that these columns don't even exist. I would take them out, except I need to keep them in. So that if you fall short of the requirements in this column, I can tell you why you ended up with the summary of Hudson versus Michigan in this column here. Okay. When it says incomplete or incorrect summary of the case, demonstrating understanding, I want citations and references. Remember what I told you about citing the case. So I'm going to talk about this column every week, mastery. You should appreciate that because that'll help you to excel. And if it was me, and when I was in school, that's how I made it as far as I did into a good law school after college, is because I worked hard to get honor roll and dean's list. Same thing with Missouri versus McNeely. Same exact thing. And then I want an outstanding explanation of the exclusionary rule and how it works. And I'm going to talk about the exclusionary rule in detail tonight before we leave here. Exceptions. Identify any exceptions to the exclusionary rule that may have been either applied in the case or understanding. If there are none, they say there are no exceptions in this case or the other case, and explain why. Credible sources. That's what we already been talking about that, all right? And then look what it says. Professional language. So let's say you did this and you did this, but then I get down here and I see that your paper was 2 pages long or 2 3/4 pages. then I'm going to have to put you over here because it says that you did not meet the 5-page, I'm sorry, the 3-page minimum requirement. That's the important thing. So you'll lose half the points down here. Now, some might say, oh, that's 5% of the grade. Trust me, it calculates out when the computer gives it, and you could end up with a C or either a D in some instances, depending on what you did up here. Any questions about the assignment at this point? Type in the chat box if you have any. If you don't have any, type in the chat box. Any questions? Okay. Any questions? Jacqueline, I see Valerie said no. Any questions? Okay, because I try to make sure that you, okay, thank you. I try to make sure that you're interactive with me, but I also try to make sure that we're up to speed. I don't like to leave students hanging. All right, you got an advantage too because you have the course early lecture in the week, so your assignment's not due until 6 days later. So then you got your discussion assignment. Once again, the exclusionary rule and how it applies in a real world scenario. You'll know that because your research will help you, and you're going to use this scenario. Oh yeah, the famous um, head in the freezer case. Yeah, this is a good one. I love reading these responses from students. Very important. Uh, uh, and it's funny. It's really kind of hilarious, but it brings to mind some real cases that that I've had before. It does. So yeah, and because I just completed this course. Usually they don't have them back to back, but I just completed this very same course, uh, term 1 for the fall, and all throughout the whole time, my students said one of their favorite discussions was discussion number 2 about the head in the refrigerator, and you'll see why in a minute. So in your initial post, excuse me, you're going to explain the exclusionary rule, discuss if the exclusionary rule applies to the scenario, and justify your answer. If the exclusionary rule applies, what are the potential ramifications? So what will happen if it does apply? And then support it with sound legal argument. I don't really care about citations, but they are helpful usually in these kind of scenarios here, okay? And then that's due tomorrow night. Then Saturday, another post from another student. Remember, we have what we call post first, and it's hidden until you put your discussion post in. Any questions about the discussion assignment? Okay, I think you're gonna have some fun with it. I mean, it's very interesting. And then your live classroom submission, where you're gonna put the key phrase and you're going to put it in to Dropbox. And the advantage of coming to the lecture tonight is you can get your first grades tonight because I will check it off then. Okay. So we're going to talk about now the 14th Amendment, the exclusionary rule, and exceptions to the exclusionary rule. All right. And then closing out with the knowledge check as well. So anyway, so what's this thing about the 14th Amendment? First thing you should be aware of about the 14th Amendment is this. The 14th Amendment contains several sections. We will pretty much deal with section 1 of the 14th Amendment. And the reason why is because it's where your due process issue comes. And due process, of course, is the right to have ability to respond, the right to a hearing, the right to receive the charges that are against you, um, the right to respond to those charges, the right to um, uh, a hearing or an opportunity to be heard before you are either sent to jail or prison or property is taken from you. So I will read this. It says all persons, and then one other thing I will tell you in a minute, and you'll see it as I read it. All persons born or naturalized in the United States and subject to the jurisdiction of the United States are citizens of the United States and the state where they reside. Okay, so far we're talking about natural or either naturalized or born individuals. So it says that no state, tell you why it says no state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States, nor shall it deprive any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So when you first read the beginning of this 14th Amendment, you begin to think, aha, if you're not a citizen, it doesn't apply. But if you read the thing all the way through and put it in the context, the answer is no. The point of the matter is that our law and legal system is set up on all those individuals that have those rights. Now, there are some minimal rights or some rights that are not there. For example, if you're dealing with the federal law, the Patriot Act. You all know about the Patriot Act, right? You ever heard of the Patriot Act? Have you ever heard of the Patriot Act? Okay, it's before your time, probably, or you could be little. September 11th, yes, okay, Jacqueline knows. We had the September 11th attack, which resulted in the World Trade Center, the two towers being coming down. And after that, we went into a new recognition of domestic and international terrorism. That was an example of international terrorism because it was a foreign emissary that initiated the action on our soil. And so the Patriot Act came up with the requirements that you had to go through. I mean, we had to already go through metal detectors before that, but you have to go through so many other things. It began to move toward changing the amount of identification. And one other important factor, uh, people had to start traveling very carefully with things. There were certain items that were prohibited from being able to carry on airplanes and public transportation and things of that nature. But you know, we're in an era now, post the Patriot Act, where if a person is uh, charged with that, then they might have some rights that not necessarily um, others would have. In other words, the 14th Amendment uh, protection is relaxed, and you'd have to look at the Patriot Act itself. It doesn't apply here, but that's what I wanted to say. So now, anyway, ordinarily, before the 14th Amendment existed, which was 1868, the Bill of Rights, which are the first 10 amendments to the Constitution, and the Bill of Rights that apply pretty much to our criminal justice classes consists of the Fourth Amendment, search and seizure, the Fifth Amendment, um, right to self-incrimination, the Sixth Amendment, speedy trial and right to counsel, and the Eighth Amendment, cruel and unusual punishment. Those were the primary um, amendments that were involved here. And so what happened is that when the 14th Amendment came, it applied those first 10 amendments to each state. That's why it says in there, no state shall. A lot of people are surprised to hear that when the Constitution was first written, it didn't give these, the Bill of Rights didn't apply to the state laws. It applied only to the federal laws. But 1868 is when that changed. And so then, anyway, we don't deal with too much Section 2, and because it deals with other things. Um, so it changed slavery and things of that nature, dealing with the Missouri Compromise. That's a little history, but Section 3 and Section 4 and 5, you can study that on your own, because that pretty much deals with the First Amendment or the rights of individuals, the civil rights laws, and so forth and so on. Okay, so let's look at the fact that each citizen has these rights, and it is important for you to understand that when these rights are in place, they're there to keep things organized, and it is important to recognize what it means. When we start talking about privileges and immunities, so the privileges and immunities, and in the case of Twining versus New Jersey, 1941, the court gave some examples of what are privileges and immunities. And it's basically the right to go between state to state. In other words, you don't have to have a passport to go from Illinois to Indiana, or any of our countries, our states rather, uh, to petition Congress for the redress of grievances, the right to vote, the right to enter public lands, the right to be protected from violence when in the custody of the U.S. Marshal, and so forth. This is some of it, but these are what they mean by privileges and immunities. These are things that people probably take for granted, all right? But that's what that language actually means, all right? Now, when we get to, again, I've already kind of explained the due process aspects of the due process clause, but you have to have a hearing. You have a right to a trial by jury, and then it also incorporates the right to in public cases for individuals to be able to have who they want to be in the courtroom. As those of you who may be aware, in the law here, I'm in the news here, and I pay close attention to it, in the um, the case of the young man Aubrey uh, who was killed in Georgia. The defense attorney being upset because black pastors were in the courtroom supporting the family of the victim. That was stupid. That's all I can call it. It was stupid. What law school did this person go to? And he's going to try to declare a mistrial? But no, you can't do that. That's part of the process. It's open. The only courts that are not open generally to the public are what courts? Anybody know what courts are generally not open? There you go, both of you, juveniles. Absolutely. And that's for protection of the minors. But other than that, anybody can come into the courtroom. I mean, as long as they're not creating a disturbance. So uh, I I just I shook my head when I heard that, and I couldn't believe that in 2021 that I was hearing that. I couldn't, and You know, I have to say this to you guys so you understand this, is that when I started practicing law in 1978, I went into a courtroom in a suburban area of Chicago. And when I was sitting on the front row, um, the bailiff came over and said to me, excuse me, but are you in the right place? So I stopped and I looked. It says, attorneys, this is the attorney's row. I said, well, I'm not pulling out my bar card to show you, but I'm an attorney. Oh, he got very defensive then, but I knew what he was doing. And he said, I just never seen you around here. I said, yeah, okay. I said, this is a public courtroom and attorneys can come in even if they're not representing someone and still sit on the front row. He said, yeah, you're right. I apologize. And I mean, I'm saying all of that to say that was in 78. Okay. That's a long time ago. But to hear something even close to that in 2021, it kind of blows me away. But anyway, so the point of the matter is that you have a right to those kinds of things. Um, any person means the right to procedural due process applies to all people. That's why it says the any person part. So it's not just citizens, as I said, but to all those. Um, James Madison in 1789 was passionate about his Fifth Amendment clause being applied to the states. And he said that the freedom of speech or press and right of trial or jury should not be infringed by any state. So anyway, courts and Congress have debated that, but and then finally when the 14th Amendment passed, it fixed it. It fixed it. Okay. Equal protection of the laws. I talk about that in one of my lectures. I don't know. I think they changed it this term, but I know before it used to be. So anyway, it's fundamental fairness, and it's like peanut butter and jelly. You know, cheese on it. How do you have a cheeseburger and you don't have cheese on it? But anyway, everybody get where I'm coming from. You see my point? Okay, all right. One thing about that you'll get from me if you've never had any classes from me is you'll get down to earth, up close, real and personal things that are happening that you need to be conscious of as criminal justice professionals. So anyway, we look at the 14th Amendment and um, and the due process rights and the court processes that take place before a person either pleads guilty or is found guilty. Okay, person, look at this. I like to read this one and then say it. Due process helps ensure the accused's rights are protected and innocent people are not convicted of crimes they did not commit. That's why we have that. Some fall through the cracks, though, and that's the case. That's why you're presumed innocent until proven guilty. That's what the system says, and that the burden of proof is on the prosecution in criminal cases to prove beyond a reasonable doubt that people are guilty of the offense for which they are charged. And reasonable doubt is a very interesting standard. It means what it says. If you have one scintilla of doubt in there, then you can't find that person or should not find that person guilty. That's what we defense lawyers worked heavily on. We didn't care about knocked out punches. We were like boxers who scored points by jabs, and that's what we did. And till the jury got to the point that they said, "Oh, we don't know if we have the right person or not, or if this person did this." So, but that's what the process is all about, and it's not the best in the world, but it's better than many countries have. So now let's talk about my favorite topic as a defense attorney, dealing with the exclusionary rule. And the exclusionary rule, you're going to discover here. And if you look at these fact patterns, then that fact pattern, I'm going to skip over it, but I'm going to talk about it in the lecture as we proceed. We got about 10, 12 more minutes. Evidence that is utilized in a criminal trial must be properly collected, must not be used if it was illegally obtained. So all the evidence has to be legally obtained, as it says here. The exclusionary rule is the reason why illegal items are not. Illegally seized evidence cannot be used at trial, with a few exceptions, and we'll talk about that. And so it's important for you to understand that it derived from two landmark cases, and that's Weeks versus the United States, a 1914 case. And again, I want the full citation if you use that information. And Map versus Ohio is the other one. Okay. And we're going to go over these right now. Okay. By the way, just so you know, if you were to scroll down, let me just show you for a minute. It shows you the full citation that I talked about there for Map in 61 and Weeks in 1914. So I don't know why they didn't just put it in the body, but anyway, that's, I don't know. Anyway, so in the Weeks case, it was very interesting. This person living in Missouri was suspected of, as it says, illegally mailing coupons or tickets representing lottery, a violation of the criminal code. He was arrested without a warrant at his workplace because police officers had gone to his residence. The neighbor told the police where the key was kept, and they entered and found various items, and they were turned over to the U.S. Marshal. And so anyway, he was tried in federal court and subsequently convicted. He had previously said, hey, wait a minute, that was my private property. It should have been returned. The court said, nope, but he appealed. And the Supreme Court justices examined if his house, the search of his house, remember this was a business thing, and if so, should the evidence have been permitted? The court said that it was an unlawful search and that the evidence should not have been used against him in the trial court. And the rule thus came about, where it applied the rule to federal authorities because U.S. Marshal was part of the seizure. In contrast, the papers were not seized by police of any claim of federal authority. Therefore, the exclusionary rule did not apply to state officers. Of course, though, that would change 50 years later when you'll see that and coming up in a little bit here. All right. So the point of the matter is that it made sense for it to be excluded because his home they had no business searching his home without a warrant. Okay. So because they couldn't use that evidence, and guess what? He was free. So here's a very interesting, the Map versus Ohio 61 case, which changed, extended Weeks, should I say. It made the exclusionary rule apply to the states now. Remember, Weeks to the federal government. Miss Dolores Map. We used to laugh about that. Dolores. So there's a side reason for that. There was a cat called Dolomite, but that's a comedy thing, but everybody used to talk about that while doing this studying. Anyway, she refused the entry to her home and called the police. The police returned hours later, and uh, the officers entered without a search warrant, and they snatched the items from Dola Ray's hands. I said she, I meant he, his hands, and they tried to. No. They wait a minute. I thought Dola Ray was a female. An officer held up, and the way they got these facts here written, because I remember in the original case reading years ago, snatched from his hands and tried to conceal among her bosom. Okay, all right. So they tried. They struggled with Dola Ray, and oh, okay, they had the warrant and handcuffed her. So the officers continued throughout the residence and located materials that was obscene material. But the reason for the original search was for not obscenity material, but for what? What did it tell you early on? Bombing material. Okay. So, um, so at the trial, the police could not produce the warrant, but she was still convicted. And upon appeal, the United States Supreme Court reversed it. Talking about in Wolf versus Colorado, a 1949 case, it says if states were required to exclude illegally seized evidence under the 14th Amendment search and seizure and the 14th Amendment due process clause, the court concluded the exclusion of evidence may have been an effective way to deter unreasonable search and seizures. Other methods could be equally effective. And so there were civil remedies that the public has. So with her being convicted within the Ohio court, and she appealed to the U.S. Supreme Court, and the Supreme Court granted what we call a certiorari, which means they granted an opportunity to hear the case. When you see certiorari, that's what they're saying. And in a unanimous decision, that means 9-0, the court said, wait a minute, that her Fourth Amendment rights prohibiting unreasonable search and seizure were clearly violated. Now, before you even read the case, just listening to what I've said so far, can you see why the court said that should be extremely clear? Can you see? Everybody see that? Or, yeah, because, I mean, come on, you can't do that. All right, law enforcement doing the job has to do it right. And so the evidence should not have been used against her at trial, and the case was reversed and sent back to the state courts. And they applied the exclusionary rule to the states, starting in that Map versus Ohio, and has been applied since that time. And then the infamous Miranda versus Arizona case applied the exclusionary rule to confessions, and it's applied today. Okay, so we want to have trust, as they say, with law enforcement. It says, and if law enforcement breaks the law, it can breed contempt and trust. So it was overturned. So now we conclude this pretty much with talking about the fruit of the poisonous tree. Now here's the deal from that. Now you already know about how the exclusionary rule prevents evidence from being used at trial. And the reason why this happened is the concept of what we call, it is the fruit of the poisonous tree. In other words, the tree was poisoned and the fruit that was produced should not be used because it's poisonous. Okay. The doctrine was established in the Silverthorne lumber case in the 20s. And in this case, evidence was obtained pursuant to an unconstitutional search and seizure. Any evidence obtained from an unconstitutional search and seizure should not be introduced in court, period. And it excludes, and the exclusionary rule extends the evidence unlawfully seized. So any fruit of a crime obtained illegally cannot, I repeat, cannot be used in a court procedure. Therefore, if the police violate the Fifth Amendment rights to silence or the right to an attorney, the Fifth Amendment rights, as was done in the famous Miranda versus Arizona case, and the Sixth Amendment Gideon versus Wainwright case, where Mr. Gideon represented himself during a custodial interrogation and wasn't given the right to counsel. And as you already know, in Miranda, that was one of the rights that was mentioned in the Miranda case that came out. And so it violated the Fifth Amendment. And so if you have one of those things happen, you can't use the evidence. And the way that it happens, guys, is it can be brought in, but then the defense attorney does what I did many times, is we file what we call a motion to suppress. And the motion to suppress is to, and this is before trial, and the judge will rule if it violated the Fourth Amendment, Fifth Amendment, Sixth Amendment, then the item would be tossed out and it could not be used at trial, which substantially weakened the prosecution's case and resulted in them dismissing cases. Okay, so I'm gonna not ask you, but pretty much on what you've learned. So you think David's in trouble? Yes or no? We're almost at time. But if you haven't had a chance to look at the facts, don't worry. You go back and look at the facts that we started talking about earlier. But the answer is no, no, and you'll see why. And it's important. It's a real good tactic. A lot of people say, well, that person, they got off on a technicality. Police have to do the right thing. Law enforcement, prisoners are entitled to. All are entitled to it because of the Constitution. And so there's some exceptions, and we'll talk about that, not today, but we'll talk about that next week. Okay. Now, this is for you. I'm gonna just hit it, keep moving. And this is just for you to study for. That's why it's in there twice. So as you go through this, you'll be able to learn about these. If you have any questions about any of these, and then it also gives you a lot of details, and it gives the cases there. So I'm not going to go through that, but that's something that you guys can study on your own about exceptions to the exclusionary rule. And I will also provide you with some information that I had from when I taught this before, not last time. Then the last thing is the knowledge check that you're going to be able to just go over yourself once you're finished. Now, let me just ask you a couple of these. Tell me, the right to pass freely from state to state, to petition Congress for redress of grievances, and the right to vote are examples of what? A, B, C, or D? Which one? You said B. Okay, want to take another shot? D. I like C. Remember we talked about the privileges and immunities, basic stuff like the right to vote and things like that. And remember we mentioned previously earlier privileges and immunities. That's an example of that. So the correct answer is privileges and immunities. Procedural due process relate to the rights of process using guilt or innocence. Substantive due process rights relate to the laws, and if the law itself is constitutional, and the fifth relates to the procedural due process rights, among others. But it was actually privileges and immunities. Okay, then this is the last one. What is the landmark case that first established the exclusionary rule? I kind of touched it, didn't I? Yeah, it's not Gideon versus Wainwright because that came way later. Miranda versus Arizona came before that, and then Arizona versus Gant came even later. But it is the Weeks case. Yeah, the Weeks. Um, the Weeks case correct. The Miranda case established Miranda rights. Gideon dealt with the court-appointed attorneys. Gant dealt with search of an automobile incident to arrest. And I'll provide you with some information that you can have for that as well. All right, so I'm going to stop so you could go through and you can do these things and they will help you. So, any questions about anything tonight that we covered? No, I know you can't speak. That's why I say type in the chat box. That was earlier. Okay. Yeah, I muted you. Okay. Make sure to say privately and not, I mean, take it off of privately to everyone. All right. So, you don't have any questions? Should be one question. Okay. Change that to, yeah. Valerie, you've been in my other classes because I recognize your name. Am I right or wrong? No, you weren't in any of my classes before? Seriously, I thought I recognized your name. Oh, okay. I don't know why your name seems so familiar. I know Jackie's name didn't seem familiar, but the answer, you want to take a shot at it? That's a great name. Okay. That's close. You can tell me why. The answer is exclusionary rule. That's it. That's it. Okay, so give me exclusionary rule and drop it in that drop box and you get all your points for this week. Okay, this is a very interesting topic. I'm telling you, it's not boring. It's very invigorating. I love it, and I love teaching this course. They did a fantastic job when they redid it. So anyway, I will see you next week. I will go back and I will try to find the material that I had that had some exceptions to the exclusionary rule that I will just send you in an email right after class. All right. I may have known your mom. Who is your mom? What's your mom's name? That sounds familiar. I don't know why, but it does sound familiar. Um, it does sound familiar, but I don't know. Um, but wow, that's something. I'm getting. I have had. Okay, I'll unmute you. Let me do that. Okay.
My mom's name was Patricia Suda Williams, and she married a Nash. And she was a friend of Mary, of Miss D.
That's why I know that name. That's my mom. Yeah.
Yeah, they grew up
Okay.
together.
Okay. That's why I okay. I knew it was something. Okay.
Yeah.
Yeah.
When you
Wow.
said that, I was like, this can't be happening.
Yeah. Yes, that is. If you ever listen to my story,
I did.
the- okay, and you heard it. I don't know if I think I mentioned her in there, didn't I?
Yes, you did. You
Yeah.
asked
Yeah.
her to
That's
be
my
your mother.
mom. Yep.
And I
I
was
asked her to
like,
be.
her and my mom knew each other. They were friends.
Yes.
They grew up
Yes.
together.
Yeah. She. I was 14 years old. And my mom just turned 85 October 30th. That was her
Uh-huh.
birthday. So she's still doing well.
But
And
my mom is
yeah,
gone.
she's
She's
gone. Oh,
passed. Yeah,
sorry to hear that. But I'm sure she did a good job before she left you. So,
yeah, she did.
but yeah, my mom is, she's, 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 she's kicking there. So, but wow, I never would have got that one. I'm stopping the recording, but I never